And I think on the defense side, what may end up happening is substituting one for another, because odds are there's not going to be tremendous disparity of the amount of discovery involved with any one of those custodians versus another. If you've got a defendant who's trying to facilitate discovery and get to a resolution of the matter, you know, I can understand the suspicion on the plaintiff's side of pushback of substituting one for another, but my main focus is typically going to be, given the size of the case, given the number of people involved, where can I limit that first tier at as far as numbers and amount of data that it's going to involve? Maybe rather than trying to play shell game with who these custodians are or where these data sources are that we're going to open first.
And so that kind of illustrates the point when I said it's like doing discovery on discovery. So on the front end, it's important to take a couple of 30B6 depositions, obviously corporate organization, but also on ESI. How do you maintain your documents? What's the policy that you have in place? Where do you keep them? When do you archive? How do you archive? To get a sense for, okay, if I'm going to get an objection and it's going to be under the heading, it's disproportional or it's very burdensome, well, I want to know how burdensome it's going to be, right? And so that will give me a good idea, and it's going to be a guidepost going forward throughout the litigation. If I can go ahead and lock down some of that testimony early.
And we need to not lose sight on what is the average case. Not the large discovery. We're talking about 5 custodians, 10 custodians. We're talking about a small business with 3 desktops and a server. One of the other factors in here that's been roped in proportionality is the relative resources of the parties. There may be a lot of money at stake, but if you're talking about a small company with an entire annual budget of $2.5 million, it changes the entire discussion about what you're going to do to try and extract that data for discovery.
Hey, real quick, just by a show of hands, do we have any plaintiffs' lawyers in the room?
Law clerk.
All right.
Just law clerk.
Good.
All right.
All right. I'm just trying to get a sense. In practice areas, is it primarily business litigation? Nodding.
Yes.
Okay.
Yes.
I'm just trying to get a feel for.
I'll just say from my perspective, in order to start discovery, I like to put on the hat of corporate counsel. I like to issue a 30B6 deposition notice and go do the same thing that y'all do. Have the corporation put a representative up and say, all right, who was involved in this issue? How were they involved? Who was their supervisor? What departments were involved? I mean, that's what y'all do when you get discovery. I'm just going to double check you did it the way I would have done it. And ask the company those questions. And then I'm armed with information in the meet and confer process that we can then begin to negotiate which custodians we're going to do. Because as Kristian said, I'm very reticent to allow defense counsel to tell me who are the important custodians. We may agree after I take that deposition. We very well might, but there may be a disagreement over a name or two, and I think that's a healthy way to proceed in discovery, where everyone knows sort of where are the buckets of available information. I may choose poorly. Paul may say you need to talk to Jim, and I say, no, it sounds like Doug knows more about this, and it turns out I should have had Jim's information, and I got Doug's instead. But that's a decision I think my client wants me to make, and so that's an easy deposition to take. It doesn't require a lot of prep on the defendant's side, and you can take a targeted deposition without a lot of time and have more symmetry of information going into the meeting for discussion.
Well, and similar, looking at it from a defense standpoint, and some of the things that Kristian and Jerome were talking about as far as being suspicious and a little bit of, maybe healthy paranoia on the plaintiff's side. The defendants, especially the serial litigants that always have large volumes of litigation going on an ongoing basis, cost is one of their largest factors. And when we're in court screaming about the cost of the discovery being requested by the plaintiff, I can almost guarantee you we have not gone through all that data and parsed it and analyzed it and reviewed it and looked at it to know what's there to be able to formulate the shell game that we're always being accused of. We're trying to cut down on costs. So the odds of us having gone through and already ourselves combed through the data to the degree necessary to play the shell game we're often accused of is just really not realistically going on.
How much of a factor does early data assessment play in that? Do you?
I mean, you're going to get your key documents. You're going to do your custodian interviews. You're going to talk to the key people involved in it and exploring about what the case is about anyway. And they're probably going to bring you at least some of the key documents in the case at the start, even if you're not using some sort of ESA tool, ECA tool, or doing some sort of analysis through the documents before you need to at least done that amount before you try and sit down and start having these discussions.
Okay. All right. Let's. We've talked about Rule 26B. As you can see in the slides, we've got a number of examples. Let's talk about it in terms of its emphasis on ESI and some of the factors there.
Well, and this kind of dovetails with what you just said. Defendants are going to produce the key documents, and the defendants are going to put up the key witnesses in the case during discovery. But there are two important considerations. Now, this is all insight for you to what the plaintiff's bar is thinking, I guess. But so there are two specific considerations that I have when it comes to the documents that are going to be produced. First of all, what is your document retention policy generally? What is that? What are the policies, and how does that work out practically in whatever the business is, whatever the corporation is? And then second of all, how are you, defendant, going to identify the documents that you are going to produce to me? Typically, oftentimes, what defendants will say is, here's what we're going to do. We are going to search in these buckets, whether it's a database, whether it's custodial files, whatever it is. Here's the buckets, these custodial files, these databases, this whatever. And we are going to search for these ones. And then whatever hits, those are the documents that they're going to pull. Those are the ones they're going to review for reasons of privilege. And then they'll say, and then we're going to produce them to you however they want to produce them. Typically, it's defendants don't want to produce in native format, they want to produce TIFF images or whatever. But those are two important things, because if you don't know what they're doing as a matter of having course routine, what their policy is with respect to their the documents that they maintain, and if you don't know how they're going to look for documents before they produce them to you, you don't know if you're going to get relevant information. And just to kind of, I'll give you one small example. So in Shantrick's litigation, we went through this whole process, and we also agreed that we could come back and we could give them additional terms to search for. Well, it comes to find out that there was an alphanumeric series of numbers and letters that they were using to refer to Shantrick's when it was first being developed and before it was put on the market. We didn't know that, but that turned out to be a very important piece of information, because then once we started actually searching the documents that we did have that were produced to us, we started finding just some interesting threads of communications, correspondence, and commentary that was going back and forth.
I will say, just as an overall framework, that don't panic when you hear ESI. It's not a legal magic word. There are very few of those. I'd like to speak to my lawyer in the criminal context, or magic words in the legal context. It alters the behavior of everyone when those words are uttered. ESI is not. ESI is something we have to deal with. It's a part of our changing world. But I like to think of ESI discovery in much the same framework that we all thought of discovery before it became huge. And I think of servers as filing cabinets. Which department, which filing cabinet has the likely documents in it? It's just another file system. And as long as you take your framework of how you're going to approach that filing system and understand that how we as people keep files together, and you can do the beginning discovery to understand how this organization keeps their files together, then you don't have to be intimidated by the fact that it's electronic discovery. And you can start to have meaningful discussions about how do we get to the right stuff versus, Paul doesn't want to go through gigabytes and gigabytes and gigabytes of information to produce it in a case that's not going to make any difference. I don't want to review it. I don't want to look at it either. We both have ultimately a similar goal: is let's get to the real documents that matter in this case, and get them out there, and we can argue in court later about what they mean and which ones are going to be useful to trial or not. But how do we get to the point that we find the right documents? His client doesn't want us to pay him and his vendors to go collect all the wrong documents. I don't want to spend attorney time reviewing the wrong documents. We ultimately have the same goal. So how do we come together and amass the information so that we can collectively make a decision to get at the right documents?
And you talked about this second bullet point, talking about the deposition of the defendant's IT person. Can you talk a little bit about IT's role in that and how they bridge that gap between your focus of filing cabinets to the actual technical information that's being stored?
Yeah, a couple of points here. We all speak English, but we're speaking different languages. If you ask in-house counsel, outside counsel, IT, and the engineers the same question, you're going to get 4 different answers. And most of those aren't going to be able to understand each other. There are more and more courts that are asking parties to bring their technical people to the meet and conferred at this level. The second thing I would throw out there is that what lawyers need to realize is that a company's the way they store data is very different than your average law firm. Your average law firm, even a large one, has some sort of case management system, and all the documents relevant to a particular case are all in one place. Probably the same server, but obviously as you get into larger firms, it's not necessarily the case. The IT environment of most companies is Frankenstein's monster, because the companies have gone through changes. There have been mergers, acquisitions. There have been new systems that have been implemented, but it was going to cost too much to import all the data from the old system, so they kept it. So then whenever in the course of their operation, they may have to look to a couple different repositories. I don't say this to detract from Jay's filing cabinet analogy. It's a very good one. It's one I've used in arguing motions with the judge. But it, in some ways, is more complicated than that. And it's something that lawyers on both sides of the case have got to keep in mind, and it again drives the cost factor on the defense side.
Right. In essence, we keep a little filing cabinet with us wherever we go, and so you've got to take into account everything from servers to web-hosted data to mobile devices and so forth. So it's definitely key to have an IT involvement in the process to help coordinate and figure that out.
Yeah. Go ahead.
To me, one of the main changes to the definition of the scope of discovery that I think is going to be interesting to see develop is if you look at the factors that were brought into the definition of scope of discovery with the changes to the rule, most of those factors were already in the rules. Instead of being put into 26B1, which is the definition of scope of discovery, they were in 26B2. But they were set up structurally to be in a way that they were only really triggered on a motion, probably for a protective order, to limit the scope of discovery. If you look the way old Rule 26 is written, that it says the court can limit discovery based on these factors. It was the exception for those to be considered rather than the rule. But I think part of the way these changes reflect the increasing emphasis and involvement of ESI, it's being accepted that large amounts of data are coming into play in most cases at this point. What's considered large, I'm saying relative to the size of the case. A car wreck with 2 parties could have a large amount of data when compared to the injuries that are involved just by having 2 cell phones involved and the amount of data that could be on those cell phones. So now by bringing those factors that used to be used in a motion to limit discovery in the special circumstances are now brought into where they're the focus of the scope of discovery in every single case.
Yeah, and I would just add that Paul's absolutely right. I mean, these are not new discussions in large cases with large data. I mean, they've been going on for a while. The rules just finally really sort of codify those discussions in the ARCA case law. So this is, I mean, it's a change in the rules, but it's not a change in practice. And from our perspective, that evolving practice of focusing on what do you need, how are you going to sift through this data, what data do you really need access to, I think has made me a better lawyer. gone are the old days of you file a complaint, you do some discovery, see what you can find, and then decide what kind of expert you need. You need to know when you file your complaint what kind of expert you're going to hire. You should have already retained that expert as a consultant to help you frame your complaint. You need to talk to that expert about what documents he would expect, because he's the expert in the field. What do experts in the field? What do they look for? What should be there? Talk to your consultant who's going to help you, if you're on the plaintiff side, with the data management. What do they think? How do they think these files are going to be structured? How do they think these databases are going to be structured? And you're absolutely right, Paul. I mean, we're all speaking English and nobody's talking to each other. And so get those two experts together to consult. Use the tools that are in our toolbox of lawyers of asking questions till we understand it, and have these people have a conversation moderated by us that we ultimately walk away with an understanding, so that we can go talk to our counterpart on the other side of the aisle and have an informed discussion. And somewhere we seem to figure out how to talk it through and get there. And if it works really well, we can leave that meet and confer and go explain to those folks what we just talked about. That doesn't always happen either. I mean, it's not always possible for Paul and I to have a meet and confer and then go back and talk to our respective experts and in-house folks and communicate with them in a way that they understood what we just agreed to.
We were literally just talking about that before we started the program, and I was just telling the story how I've got a case recently filed in the Southern District of Illinois, and so we're negotiating our ESI order, and the firm that was handling it for the defendant, they had their own in-house person, and finally I realized that I was outmatched. It didn't take long for me to realize that, so I hired an expert to help me consult and sort some things out. And it just so happens that the expert that I hired happens to be the same company that that basically got the client or got this particular defense firm sanctioned and fired in another large mass tort case just 2 years prior. So the important, and bring it full circle to what Jerome said, as long as the conversation is moderated by people that are on the same page and speaking the same language, then it works. Because when I brought this individual into the conversation shut down. The progress that I thought we were making and I thought he was going to help put us over the line ceased. Because their position from that point forward was, we'll just submit 2 competing orders and we'll let the courts do that. And it took a couple more calls to kind of bring them along, to let them know that we're not we may be asking for the sun and the stars right now, but that's not what we're ultimately heading here. So anyway.
All right. We have a few more slides in the proportionality area. We talked about predictive coding, which I guess to give you a little bit of background, we talked about data volumes and complexity of it. It's been reported by a number of sources that data in the world doubles about every 1.8 years. So about every 2 years, you're dealing with twice the amount of data in organizations that you had to deal with 2 years prior. So they're using technology such as artificial intelligence to basically determine relevancy of documents based on other similar documents and their content. Don't know if you guys really want to have any comment on that, or if we want to move on. How many of you guys have heard of technology-assisted review of predictive coding? Okay, a handful of you. So it is, for large cases, a way to really get through a large collection quickly, determine relevancy. But it does. It is becoming more of a trend to be aware of. Any comments?
Yeah, one comment on that. So when you go through this process using predictive coding, documents are being pulled, and courts are really there's a mixed bag across what they're inclined to allow. But I always want to know if the documents that are being pulled through this technology-assisted review, because the programs get smarter and they learn with more data as it gets inputted into the system. But take some sampling on the front end to find out if we're really getting the relevant documents. If we're getting the custodial files and the documents that are key, as you've already had. And so, as long as everyone is operating on the same page, we're really trying to get the same thing, which is, we don't want to waste time and money, you don't want to waste time and money, but we do have a job to do. Then it helps to kind of do some random sampling on the front end to make sure that the documents that you're pulling with TAR are the right documents.
And I think it also leaves room to be creative. I had a large case against a big Silicon Valley tech company that everything they had was, you talk about Frankenstein, but everything they had was proprietary. I mean, their whole design of their servers, their systems, the encoding of the documents and how it went in. I mean, you couldn't hire an expert who could explain that to you.
You can tell it. He sued Google.
And lots of their folks, I mean, they were so compartmentalized that lots of their own engineers in-house didn't understand how bits and pieces of the system work. I mean, getting your head around how they store data is just, it's virtually impossible. But we tried to come up with a creative solution for how we targeted discovery, and I'm not sure there's any company with more data than they have. So just the scale of it was overwhelming. We ultimately ended up with an expert that I thought was a very creative approach. He had created a spider of sorts that was going to go and live on their server and mark documents, which then would be turned over to defense counsel to review for privilege before they were produced. And everybody in the case thought this is a very cool and interesting idea until everybody said, well, wait a minute, what happens if this works? And what does that do to other cases? Ultimately, we resolved the case before we launched the spider. But it had been reviewed by their in-house folks and confirmed it wasn't some Trojan horse that was going to take over the world. But I thought that was a very interesting approach. We'll design our own search criteria. And we'll run our program on your database, and whatever it returns, we'll mark that corpus of documents to make sure we're talking about the same thing. You're all reviewed and produced.
All right. Does anybody have any questions before we move on? We're going to kind of shift gears and kind of get into early requests for production and the strategy around those. Anybody here with questions? Okay, we'll move on. So let's talk about the strategy considerations when it comes to early requests for production.
I think this goes back to the point that Paul had made earlier, and it is true that we are tending toward, in this discussion, probably will stay on the trend of large cases with large data sets. But ESI can be involved in any case. I mean, I'm sure up the street at the domestic courthouse that because we carry around these databases with us every day, that ESI should be very important in divorce cases. I mean, it just should. And the amount of stuff that happens in lots of cases, if you don't think of an ESI case, there could be crucial information, particularly given the ubiquity of social media, that really turn on those cases. And we're finding more and more that for the same reasons that litigants in private litigation are tired of it and don't want to deal with it and don't want to go to the trouble and expense, tech companies aren't cooperating with subpoenas in many cases for social media information. They're avoiding the obligations of collecting and producing that data. They don't want to do it. They don't want to spend countless resources to have a department to pull that stuff for people in a car wreck case in Jefferson County. And so how you approach that in the garden variety cases, as it says here on the slide, is important if you want the information.
Yeah, most of the tech companies, if you try and get the data through a subpoena rather than a Rule 34 request to the party, they're going to tell you to look at the sample, but you're not going to get a response from it.
One of the other important considerations, I think, is the litigation holding itself. I always like to know when it was circulated, who it was circulated to, how it was circulated. I mean, if you're suing, someone at, the coat factory, then did you put it on a bulletin board? Did you send it out an email? And why did you do it? Why did you send it to the people that you did? Why did you disseminate it in the manner that you did? Because that will have some relevance into helping, one, give some assurances to the plaintiff that when you say, here are the people you want to talk to, and here's where we keep the data, I say, okay, well that makes sense because that's the same location that you sent your litigation hold notice to you. But if you tell me you don't want to see any of the guys that are in charge of all these archive databases, or the databases that didn't get merged, correct? But then you sent the litigation hold to them, then I'm thinking, well, why would you send it to them? Is there relevant information there? So, that kind of stuff. So I like to get as much information as I can possibly get, which, again, it's a mixed bag. Sometimes I've gotten the actual litigation hold notice that was circulated self-produced. But that's, obviously it's a rare exception because there's always a claim of privilege.
Believe it or not, on the defense side, oftentimes I like getting the early discovery, and I like the development Rule 34B about, under the federal rules, being able to propound discovery even before the planning meeting. Because on the defense side, when I am trying to figure out how broad to cast that litigation hold and what data and what custodians I need to make subject to it, a lot of times I'm trying to guess what angle the plaintiff is going to come at this from. So my client, I'm having to explain to my client why they have to put a litigation hold on so much data. It might be relevant, it probably isn't, but I've got to be careful advising my client in such a way that puts them in the position of having to explain why you didn't maintain a hold on these custodians or on this data set and suspend your regular document destruction, because I guarantee you when you get in front of the judge, it's going to be, the plaintiffs are going to make it clear as day that we should have anticipated that they were going to want that data. If I've got an early set of discovery requests in, I can already know where they are and aren't looking. Now, I need to be careful letting them completely set the bounds of the hold, because as representing the defendant, I do have superior knowledge than them, but it can help, and it can help spark the conversation about how wide that net needs to be cast early in the case.
All right, very good. We're also talking about the recently amended Rule 34B to BC, and 3 changes here, dealing with greater specificity and objections, producing responsive documents within a reasonable time, and giving express confirmation as to whether documents are being held on any stated objection. Would y'all like to talk a little bit about kind of how that impacts, those changes impact how you're dealing with the requests?
If I can jump in. Some of this I've been doing already in some of my cases. Jerome started off the conversation today talking about, yes, we're under notice pleading, but I generally, he indicates he generally gives the defendant a lot of facts, a lot of the rationale for the theory under which they're suing. But all of a sudden you get to the objections on the defense side, and it's overly broad, unduly burdensome, so on and so forth, and so on and so forth. And he's left trying to figure out, okay, which is your hill to die on? What are you really griping about here? So I've already been putting in quite often a sentence or two about why it's unduly burdensome. Well, because we're going to have to restore it from backup tapes. Or it's in the hands of a third party, that contract has ended, we're going to have to negotiate with them, just send a subpoena and we'll figure it out. It again gets the conversation started, and I'm spending less of my client's money while we're both wandering around in the same room with blindfolds on until we finally agree and meet on what the issue is here. If nothing else, I can convince my client, look, the more we streamline the process of getting through discovery, the more we can defend the case on the merits. The more there is in the budget for the strategic considerations in the case.
And the better standing you'll have with the judge when you're saying, here's what we're doing, here's why we're doing it. It just makes sense. It's perfectly rational, reasonable. And that definitely helps.
And so, as you can see there with 34B2C, talking about the objections, must state whether responsive materials are being withheld based on the objections. So you've got to cover that now as well.
I will say this: 2 weeks ago, literally 2 weeks ago, in response to some requests for production, I received 200 and either 43 or 73 pages of written responses to those requests for production. Obviously littered with a lot of objections, and 83 pages of documents produced. So, yeah, that's my feeling on general objections. I'm opposed.
Right. And we have a case really just in the past week or so where the court noted that they don't consider frivolous, conclusory, general, or boilerplate objections. So that is, I think, something that really is intended to be changed by this rule, is no more of those boilerplate objections that you see in these cases.
Similarly to, again, kind of going back to Jerome setting the tone as far as the notice pleading and putting some meat on the bone, putting what is now required by the rules with some support for the objection that you're asserting into the objection when you serve them makes me think about why I'm raising these objections and keeps me from being in the point of preparing for that hearing and trying to figure out to the judge, now that, you know, I've supposedly gone back and I should have already known what the facts were and what the situation was with my client's data before I asserted those. This requirement is going to help keep me from just firing off the standard boilerplate and then later trying to explain to the judge, well, Your Honor, I don't really know why I said it was unduly burdensome, because I really hadn't looked at that point. That's certainly not a position that you want to be in going into the hearing.
So you feel that it really forces you to get on top of things much sooner, because you have to not just object, but object with specificity, so you really have to know what you're talking about.
Yeah, and I think the fewer objections, I don't want to categorically say the fewer objections you raise, the more credibility you're going to have, but to a degree, when you get those 83 pages, there's a lot of noise there that your real arguments get lost in.
Yeah, I will say, I don't recognize any faces in here, so I don't think I've litigated against anyone in the room, but I don't go to the trouble of putting together a very detailed complaint to put up with vague, conclusory objections. It's just, if I'm going to put in the hard work, I expect the other side to put in the hard work. And I had a case in California where interrogatory number 2 over the course of 18 months was supplemented 11 times. It went from general objections with 1 sentence of substance to a 12-page answer. And it was the critical issue in the case. And it took a lot of meet and confer, but we got the issue out there. And that's really what is required under the rules, is for us to ask honest questions and get honest answers on both sides. By the same token, I don't do general objections when I object to discovery from the other side. You're entitled to more. You're entitled to know what the plaintiff has. And you're entitled to know if I do object because I'm being careful and I think that, well, you might be asking me for something that touches on a privilege issue, but I'm not withholding anything from privilege, I'll tell you that. I'll preserve that objection in case I need to supplement later, but I'll tell you, at this moment, I'm not withholding anything based on this objection.
And from the defense side, there's a way with some of these changes, especially going back to the way Rule 26 proportionality being incorporated in the scope of discovery plays into Rule 34 and how the requests are crafted. This is a place for defense side to push back on what are the frequent, overly broad discovery requests we get from plaintiffs, where it says, produce any and all documents relating to. You know, I've had a case a while ago where I was representing a company that had snagged a couple of employees from a competitor. And one of the things they were interested in was the compensation package we had offered those employees in the course of luring them away. Well, I was asked in a request for production for any and all documents relating to any company vehicles provided to these employees. And I objected to it as overly broad. During the conversation with the plaintiff's lawyer, I said, when you ask for any and all documents relating to the vehicle, you want receipts for our oil changes. You're asking for stuff about insurance on the truck. You're asking about, any maintenance we've done. What do you want?
Right.
What are you looking for? So that's a place where I think with the defense side, even though, yes, we have to put on some meat on the bone with the objections, you can really use that to push back against these broad any and all objections and try and get the client who's not focused on what it is they really need and get them to do that.
Absolutely. And as you can see by this slide, this has been a trend. A couple of cases cited here, even before the rule changes came into place. And it's already been a trend as far as interrogatories go, requiring objection specificity to objections on those. So let's talk a little bit about why documents are being withheld and kind of the aspects of the responding and producing parties to that.
Take first shot.
I figured that was getting tossed to me first.
You're the logical guy for that one.
Part of the situation that the defense counsel, as outside counsel, is in is maybe dealing with in-house counsel who is looking not just at that one case and defending that one case. Again, they're looking at their portfolio of litigation that they're having to deal with, and the information and the directions I'm going to get from inside counsel is quite often very heavily filtered through that lens. So a lot of times the pushback on what we're withholding is cost driven, because while I may understand the plaintiff's position some with pushing what's considered the permissible scope by way of pushing what is reasonable expense in that case, I've got an inside counsel who's looking at the cost of that times 100. And, you know, while we're fighting over, I don't want to talk in terms of numbers, but maybe where I'm trying to draw a line and plaintiff's counsel is trying to draw a line is 3% of the amount at stake in the case, that suddenly becomes a huge difference for my in-house counsel, my client contact across the country.
And I would assume also just in terms of just disruption to otherwise being
Absolutely.
engaged in the business to make
It goes not to what it's going to take to produce that data set. It goes to, on an ongoing basis, the size of the discovery team my client has to have on an ongoing basis as part of the operation of the company in dealing with litigation. Those differences start becoming substantial when you multiply across the litigation portfolio throughout the company on an ongoing basis.
All right. Does anybody have any questions with regards to those rules changes and how they affect both the objections to requests and the crafting of the request in the first place? Before we move on.
Let me ask Jerome and Kristian, what introductory language are you using in your requests? If you're not using, hopefully, any and all documents, how do you typically term those? How do you couch those?
Well, I wouldn't start that broad to start with. I mean, that's...
And that's my point. I'm kind of wondering, how are you coming at
Yeah, I'll give you I'll give you an example, a paraphrase example. So, and highlight another issue that I think is coming down the road for all of us, given the changes to the rules. So, in a case, issue discoveries concerning an engine defect, design documents and testing documents for XYZ engine. And what I didn't get back were general objections. What I didn't get back were boilerplate. What I got back was a rewriting of my question. We construe your question to request testing documents for XYZ engine manufactured between these dates. Well, hold on. That wasn't my question. Why did you rewrite my question? But that leads to a productive meet and confer. But what it doesn't do is it doesn't tell you which documents are being withheld and on what basis. It just tells you, I'm going to reframe the question so that I don't have to withhold anything. And I'll give you everything with this question. And that's the time then for counsel to meet and confer and say, why'd you make this change? What's going on here? And when that happens over the course of 50 discovery requests, every question gets rewritten, our healthy suspicion becomes somewhat unhealthy at that point. And we can meet and confer about the scope of the discovery and the scope of the question, but I want my question answered, and if you can't answer it fully, then because you think you've got an objection to it, then tell me what your objection is, and we'll talk about your objection, because we can sort that out among ourselves, and if not, then have the court help us on it. But I don't need you rewriting my question to avoid an objection you really want to make.
Makes sense. Okay. So let's talk about Rule 37E. There were some notable changes to 37E, basically relating to the failure to preserve ESI. So in essence, some changes were made that strikes out the part that says the court should go easy on the party. It's an honest mistake, and replaces it with language suggesting punishments for failing to take reasonable steps for things such as halting auto deletion. Some of you may be in companies where after a certain period of time your emails are automatically moved to a deletion folder or eventually deleted. Obviously, when you've got a duty to preserve, that's one of the first things you need to think about is stopping that, because those could be discoverable or relevant emails. So you've got some changes there. What do you think needs to be highlighted about the changes to Rule 37E and how that affects the preservation process?
Well, I think that ties back into what we discussed earlier with the litigation hold. And it's not a fun job for corporate counsel to think about and make sure that the litigation hold letter gets everywhere it should within the company. But on the flip side is, as plaintiff's counsel, you're 3 years into litigation, you're getting close to the end of the discovery, you finally sifted through and found the guy who was involved in all this stuff that has now left, but being represented by the company. And he says in his deposition, I routinely delete my C drive right after the first of the year every year. I just wipe it clean and start over. Well, did you get the litigation hold letter? The what? The litigation hold letter. Did you ever get a letter that told you to do X, Y, Z? No, I never got that. And so those are important questions to ask in a deposition. It's important, I think, because I don't want a gotcha deposition where some guy deleted a bunch of files. I want the files. Why not have that conversation with the other side of the aisle? Hey, let's talk about, you don't have to tell me what you're doing. I'm not asking you to breach confidence, but let's talk about who got the litigation hold letter. It seems to me that people in this department should get it. And just have that conversation. He's not going to agree or disagree with you. She's not going to tell you, yes, I gave up that person. But have that conversation. I can't be hurt as plaintiff's counsel by helping defense counsel preserve evidence that I think I may need later in the case. How does that hurt? It doesn't hurt. Why not have that conversation? And then write a letter confirming that you had the conversation.
A couple of things here. Some of the defense lawyers here may be surprised to find out there are judges and there are cases out there that hold that litigation hold is not privileged. We're generally going to try and assert that it's privileged, not always. But when you write that litigation hold, you need to take into account you may very well lose that case. Because the court looks at it and is going to look at litigation hold and say, well, counselor, can you explain to me where this is communication, of course, of seeking and rendering legal advice? Where's the legal advice in here? So write that accordingly and make sure that it's just a litigation hold and it's not coupled with some other communication with your client. I think, even though we've got some people on WebEx, I want to focus for a moment on the significance of this change to us lawyers here in Alabama. In Alabama and in the 11th Circuit, we were previously pretty much a bad faith jurisdiction when it comes to serious spoliation sanctions. In both state court and federal court, that before you could obtain sanctions for spoliation, severe sanctions like a case-altering jury charge or something, you had to show there was a bad faith in the conduct of whatever was that led to spoliation. So part of Rule 37E, the change here is going to be a change for us in that there's now a negligence standard for some of the remedies available. It's also interesting if you trace the evolution of these changes through the drafting process and the vetting process and all the brainstorming that went on. There was actually some discussion of maybe categorically separating what the court could do into a category of remedies and a category of sanctions, where remedies sought to help the side that has been disadvantaged by the spoliation, even though there was no intent to deprive them of that evidence, and then a specifically and expressly punitive aspect of it for sanctions, and that was done away with, which I think was a good development into this schema that we saw.
A clear earmarking of intent versus non-intent.
Right.
And one of the things that is interesting, a case we covered on our blog was a case where basically the plaintiff was sanctioned for, got an adverse inference sanction for failing to preserve text messages back in October of last year. After the rules changes, they petitioned the court to vacate that ruling. And the court did because they hadn't found that there was intent they found it was more negligent, so they vacated the ruling. So sometimes the intent divider line can make a difference in terms of how whether they sanction or how severe they go.
Yeah, I was just going to say one more thing. Of course, you guys know your business better than me, but it strikes me that if you have some of these rule changes, and coupled with some strong discovery sanctions, that you could use that as a catalyst for a very good conversation with your business and corporate clients, because not just for the purposes of making sure that you handle the litigation properly, but just for their general document retention policy. Because ultimately, what you want to do is this, and the pitch is, it's actually going to be cheaper for your client if they have a document retention policy that maintains documents. Here's whatever it is. This is how we maintain them, and this is where we keep them. Because if we do get sued, and we probably will at some point in time, depending upon our size, then that will translate into the way that the documents ultimately get produced to the party to the plaintiff when you get sued. And it'll be a lot cheaper if you harmonize those, and the sooner you can harmonize those, the better. Because that goes back to proportionality, and, well, the way we're maintaining them might not be the way they wanted us to, but we're certainly in compliance with all the applicable laws and regulations. And so that's what we do. And then when we produce them, this is why we produce them the way we produce them. And the production is reasonable. And so ultimately, at the end of the day, it's a way that you pitch it to your clients, because it's more efficient and it will be less expensive at the end of the day.
Yeah, Kristian's exactly right. There's a marketing opportunity here on the defense side. Several years ago, I had a client come in where they had been sued, and the conversation during the initial consult with the principals of the company turned towards data and documents and so on and so forth. The company had been around for about 4 years at that point and had grown pretty significantly from a couple of employees out of, it was your textbook case of a couple of employees out of a garage to having, I think at that point they had about 30 people working. And he very proudly, I said, I started talking about their suspending their data deletion process. And he very proudly said, "Oh, we don't delete any. Let me tell you how much more expensive this case just got for you. Let's get through this, and then let's talk about how to keep from this happening to you again, and figure out where the bounds are of the data you have to keep due to regulatory, statutory, or contractual reasons, what you need for business reasons, and what we can start jettisoning after that. Because if you don't have it, you don't have to search it.
Right.
You can turn a one-off litigation client into a business client through this."
And also the format in which you keep it, because the rules say, I think we're going to do this a little bit, you have to produce documents and the information in the manner that they're kept, or a reasonably suitable alternative, right? And if all you do is you put paper documents here and you maintain your original Word documents here and your original spreadsheets here, and that's just the way you do it, and that's the way they're going to get produced. Unless, of course, you have a protocol and a policy in place that has something different, and it's going to be reasonable. But that's the key, is that in order for it to work, it has to be reasonable, such that when the plaintiffs complain, and we do, that it's not good enough, you can still go to the court with a lot of credibility and say, what we're doing is reasonable and it certainly complies with the rules.
Right. And when it comes to reducing litigation costs, one of the best ways to do it is at the front end, by only retaining what you really are required to for, like you say, regulatory or other needs, so that when that litigation does come along, you don't have as much data to go through. You have to kind of look at those things on the front end before the case is ever filed.
At the risk of devolving again into war stories, and anyone in the room that has an IT background will kind of understand the implications of this. We had a case where, in addition to the plaintiff's claims against a variety of defendants, there were a lot of cross claims. There was finger pointing between the various defendants as to who was liable for any damages arising out of the case. And there was a lot that we were in a two-front war in that our client was involved in one of those primary cross claims between two of the defendants as to who was liable. And we were getting documents being produced as PDFs, and I mean on a large scale. This is tens of thousands of pages, hundreds of thousands of pages of PDF being produced. Not to mention the amount of data they had to cull through to get to that. So we're talking about a pretty large amount of data as far as the practices most people in the room have. And we had a lot of meet and confer sessions, and we had a lot of discussion about it, and it took that defendant a lot of convincing us and plaintiff's counsel that they really do maintain documents as PDF. Which, if you have an IT background, you can imagine how much bigger their server system must be, because PDFs just absolutely eat up volume. But it took some discovery about discovery before we were convinced they're being straight with us. They are actually storing these documents as PDF, which is just unheard of.
Right, absolutely.
The last point I would make on preservation and litigation hold that's in the presentation is it is often lost on the parties that preservation is not something that happens one time in a case, but it happens every day in the case. I had a case about 5 years ago where the critical document, exhibit number 1 at trial, was created almost 3 months before we filed suit. By the time it was produced in the case, it was on version 11, and all prior versions had not been produced. They were gone. We didn't know what it looked like right before we filed suit. We didn't know what changes had been made throughout the course and pendency of the litigation. That's not a position any lawyer ever wants to be in. And that was a problem with the client, not understanding what their obligation to preserve documents was during the case, and it was a big issue in front of the court. It was a severe sanction problem, and it was an issue sanction problem.
How often are you still asking for the litigation hold letter and finding out one was 10% in most cases?
Oh, well, I always ask for it. I'm always assured that when it's circulated, I'm always assured it's circulated to all the proper parties and everybody got it, but it's necessary. The trick is getting discovery about the specifics of that. What did you say in that notice? What documents and information, how did you describe what needed and who to get to? But like you said, it is rare, but sometimes we actually get the notice produced itself.
And I'll say in over 5.5 years of our blog, which is a daily blog, eDiscovery Daily, we've covered probably over 300 cases, and I would say probably more than half relate to spoliation disputes in terms of when the preservation obligation began, in terms of what data should have been kept or not kept, and actions, and whether there was spoliation that should lead to sanctions. So it's certainly a huge issue out there, and it's a big issue that parties deal with in terms of litigating, and because data volumes continue to grow, it just only becomes more and more of a challenge.
Yeah, and add that to the sales pitch when you're saying, and in addition to the other savings that you're going to have, we're going to avoid these spoliation fights that we're going to have to pay me to do.
Right.
But I think it also, I think the litigation hold, and I've had this come up in a case, also interplays with privilege assertions that are going to happen during the case. You ask for certain documents that existed 8 months before suit was filed, and you get an objection, well, you can't produce that. That was in anticipation of litigation. Okay, show me the litigation hold letter that went out at that time.
Yeah, that's a two-edged sword that we take into account.
Absolutely. So we've got just a handful of minutes here left. I know we've got a number of other topics we hope to get to, but we wanted to really try to keep the discussion flowing. You do all have the slides, and certainly we can provide some more information about those. I know the next couple of slides deal with discovery plan. Would you guys like to maybe just touch on that briefly and just kind of sum up maybe kind of your best advice in dealing with kind of the changing nature of discovery, and what the what the changes to the rules have kind of impacted in that area?
Yeah, I'll in all seriousness, and I think that, and this is across the board, when you're in litigation, the quality of the lawyer on the other side matters. matters. I mean, if I'm dealing, and I don't just mean that in terms of his ability, his function, his intellect. I mean, the character of the person is what matters, because at the end of the day, we don't want to have these fights. And we all know from, week 2 of being licensed, judges don't like to hear discovery disputes. But ESI is here, and I'll say this: I feel like a lot of defense firms, they're ahead of the plaintiff's bar, frankly, and a lot of plaintiffs' lawyers, particularly in smaller shops or whatnot, they don't really understand ESI as a matter of fact, but they just don't appreciate how important it is to deal with on the front end. But I think that the more trust that you have with whoever's on the other side of the V, and the more educated I am in having that conversation, I think it really goes a long way in avoiding a lot of disputes that are really unnecessary. But because, well, you described it as sort of like, Frankenstein, when you're trying to figure out where documents are. It is, and it is unwieldy. But I just think that the better educated I am, the more trust I have in the person on the other side, just goes a long way toward avoiding unnecessary disputes that again, we all know that courts just don't want to have to deal with.
I think one of the ways that, and by and large, Kristian is right, the defense bar is further along in being able to deal with these issues than most of the plaintiff's lawyers out there. On that note, it's going to be interesting to see how the change to Rule 37 with a negligence standard, what was reasonable in preservation, is going to play on the plaintiff's side, because you still have a lot of plaintiffs who are not sending litigation holds to their plaintiffs. And even in these injury cases, there's social media out there, there's text messages on the phone potentially. In a car wreck case, was the plaintiff texting while driving and that kind of thing? And I think there may be some wake-up calls served to the plaintiff's bar under that negligence standard right now in federal court, which has adopted that rule for some remedial relief. But as these changes maybe trickle down to the states, which often tend to follow the federal rules, to see where that goes as we go forward.
I would just add that I think a big issue we all should make sure we pay attention to is local customs when it comes to discovery. Local customs on these issues. And we have a uniform set of federal rules. We have a not so uniform set of local rules in federal courts along the country, but then we have a very, very ununiform set of local customs. I remember I had a products case in the Eastern District of Texas. I fly in from Birmingham, National Counsel for the defendant flies in from New York, and we go to the initial conference in front of the judge, and the court orders the production of all relevant or potentially relevant documents to any claim or defense within 45 days of the CMC. No need to go around discovery. Just turn everything over. You give them what you got, they'll sort it out. With a trial date 11 months to follow. In a big products case. National Counsel for the defendant protests and talks about how expensive and how much time it's going to take, and the judge informs all of us that he typically tries a complex patent case in 9 months from the filing. There's no reason why we can't get a products case done that fast. That case resolved quickly. But I was shocked. I was loving everything I was hearing, but I didn't know how I was going to do it. How am I going to get through all those documents and find out what they mean and how to do this? And we have to be mindful that courts hate discovery disputes. They don't like them. They don't like dealing with it. Their docket is busy with a diverse set of cases, and they don't want to hear lawyers whine about discovery fights. But when we do, and if we do it often, somebody's going to end up in trouble with the principal by the time it's over. Because courts don't want us there. They want us to work it out. They want us to find a solution and not bother them. They'll be there when it's time for trial or dispositive motions, but otherwise, y'all go do your job and come back to see me when you have a problem. And when we're there with a problem on a discovery dispute, it is a problem. And it will be a problem for the court, and it'll be a problem for whoever's misbehaving.
Great. Any questions for our panelists?
How long before state rules are modified to conform to federal rules, in your judgment?
I think we're in a very conservative state that will take a very long time.
The first set of ESI focused rules and the federal rules were 2006. Alabama was 2010 getting around to it. I think it may be a little quicker, but it wouldn't surprise me if we're not 2 or 3 years down the road.
I'll add to this. I know from talking to some of the state bar staff and some of the other judges and attorneys who are involved and have been involved in rules committees, at least as far as we can learn about legal technology, specifically eDiscovery and ethical obligation, I think we can see that pretty quickly because there's a lot of chatter about the California State Bar coming in, issuing that edict, and then also Florida State Bar now requires 3 additional trial hours of legal technology CLE, and it wasn't a 3-hour substitution; it was 3 hours of additional CLE. So I agree with Paul. I think we'll see it sooner than later. Making learning about this an ethical obligation, but certainly adopting the rules, to help along this process to make it more efficient. I think we'll see it sooner than what we did in the first round of federal rules.
And I'll just add, our blog is eDiscovery Daily, eDiscoveryDaily.com. We write about eDiscovery every day. Feel free to check us out. You can subscribe. We talk about case law. We talk about best practices. We talk about trends. Our blog posts are usually relatively short, so it's just kind of a little blurb to just give you a little bit more education each day. So feel free to check us out and subscribe if you'd like to. Thanks to our panelists today.
We knew we had a lot of content to go through. There's plenty more here. We'll be hanging around. In the essence of time, we want to make sure people get back to the offices. But we'll be around, so if you have additional questions or things we didn't cover, we'll have some private conversations with us.
Thanks for going. So hopefully that makes sense. Thank you. Nice to meet you. Nice to meet you.
Kristian Rasmussen.
Oh, thank you. Appreciate it.
Well, you're right.
That's right.
Yeah, I mentioned that to Melissa. She actually gifted me, and I did your argument at
Because too often, the younger associate
when you use an email marketing provider to group emails, they're marked a certain way. That's some companies mark it and say, well,